Good evening. How are you? Well, I'm getting out late. I had all sorts of missions to run, and with any luck, Holly and I are going to get away for a few days, but we're just checking on that right now. Thomas Jefferson wants you to know that the temperature is about 77. The sun is out low and bright in the sky, and there is no wind, and you can hear the birds welcoming the evening light. So, what is of interest? It's the same thing, except it changes, and it is the Trump trial. And I think it outshines other important matters because it's about us. It is about how we handle a person who would overthrow the government, lie to the American people, compromise their health, encourage discrimination and hate, encourage violence over law and the Constitution, attack the court because in his own interest that's convenient and helpful, and because he sees himself as a monarch, a force and power unto himself. On the stand is Trump's fixer. And Michael Cohen, over the years, and we're talking years, had to lie a lot for Trump. And Trump, we know from experience, is a liar. And because of evidence that the jury heard, they know, if they know nothing outside of that courtroom from the testimony, that Trump is a liar. And a person who looks out for himself and no one else. And who dragged his feet about compensating Michael Cohen for helping him conceal his relationships with two women who threatened to tell their story publicly, perhaps compromising his campaign to become president of the United States, and a highly relevant material given the blowout that occurred when the Access Hollywood material was released, in which Trump basically said he could do anything to a woman he wanted to and grab her private parts. Now, at the trial, we had the direct testimony, very convincing and compelling, by the government. I have heard some experts say, perhaps they should have done more. Now, here's my theory of what you should do on direct with a witness who has lied in the past and has a scurrilous record perhaps, but who's now sitting there talking about his past crimes and asking implicitly, because the government has presented him, to be believed. And so that's what we have. Now, the government in this situation knows where Michael Cohen has lied or done the wrong thing. They've debriefed him thoroughly. They have all the documents. They know everything about him. But my theory is that you tell your case through a person like Michael Cohen, and you let the jury know that you know there are things he's done, and he is a criminal. There are things he's done that were wrong, and lies, and to put them in perspective. Now, something they should do more. But you don't want to bury your story in an anticipated defense of what the defense is going to do when they get up to cross-examine him. So what do? You make sure the jury knows that you're not being taken by this guy and that you've done your homework and you've done your research to stand by the witness you're implicitly vouching for, who's telling you what a worthless piece of shit Trump is. And then the cross-examination, you expect, is going to be withering. Now, that didn't happen. It was not withering. And there may be several reasons for that. So in fairness, let's start with that. One is that Blanche, white from fear and misunderstanding, has only tried one criminal defense case before this one. Only one. Now, he was a prosecutor, and he tried a lot of cases as a prosecutor. Now, Some say the rule of thumb is that prosecutors don't know how to cross-examine. And my experience when I joined the U.S. Attorney's Office was different. And I think it's because a number of us had been law clerks. We were immersed in the law. We knew what they said about prosecutors. And I saw some brilliant examinations put together on the spot often by other, and usually older, a few years than me, other prosecutors cross-examining. But I don't think that Blanche had that experience. And I do know that years after we were having this experience as younger prosecutors, that the U.S. attorneys began to do more plea bargaining and less trying of cases. And so cross-examining a defendant in a case is rare at any time in my life, because most defense lawyers think it makes the case real when you put the person on the stand who's the center of attention. And I have that same view in civil cases. So what did Blanche do? Blanche started by saying, "You called me a name." Now, isn't that weak? I once had a lawyer stand up and say that I asked him to fight me, and he sounded so whiny that I think the judge was laughing. But she looked at me and she knew me and she thought, well, it's probably possible, and they never did anything about it. So I think a lawyer who stands up and says, "You called me a name," before he goes into all the other name calling against Trump. But does this lawyer remember that the nation has been exposed to Trump calling people names at every turn, making fun of them, and lying about what they did? Poor Senator Cruz, his dad was implicated in the assassination of J.F. Kennedy by Trump. So I think that's a wash. And I think it sounds whiny. And I think the jury is tougher by that point. Now, the beginning cross-examination, on the first day, Blanche was all over the place. Now, some others have commented that you shouldn't ask a question on cross that doesn't fit one of your major themes. That is, for example, that Cohen is inconsistent. Cohen perjured himself. Cohen is angry. If it didn't fit in one of those three categories. And I think there are others, but I think that it is good to have a pattern. But one rule of thumb, a very basic rule, is to control a witness, any witness, you have to control the questions. And the only way, and proper way, to control a question against an adverse party, in this case Cohen, is to ask leading questions. Isn't it a fact, Mr. Cohen, that you said such and such? Yes or no? Yes. Isn't it a fact? In other words, it becomes a long piece of testimony by the lawyer, ostensibly questioning the witness, but limiting his response to a specific fact. And I've talked about this before, but the key is to control your witness. And one way to control a witness is to ask him questions about things that you know, to let him know you know. So how does that work? Well, you have a witness on the stand, Cohen, and you ask him about things, and he hedges or doesn't get it quite right, and you say, well, isn't it a fact you did such and such on such and such a date, yes or no? And then Cohen, confronted with the specific, says, yeah, you got that right. He's been controlled because now he may think that when you ask a question, you know the answer, and all he's doing is confirming it. There wasn't enough of this at this trial. And here's the other thing. If at the end of the day, You attack his credibility by saying he's a liar. What was Trump doing with him all those many years when he was Trump's fixer? He knew who Cohen was. He knew what he was. And how do you get around the tape recording between Trump and Cohen talking about how to arrange the payoffs? How do you get past the document that says how Cohen will be compensated? How do you explain with some alternate explanation why in the world Cohen would just do this out of the goodness of his heart? Now, if Cohen wanted to be in the new administration, if Trump won, did he want to keep it a secret from him what he was doing on his behalf? More than that, isn't it a fact that Cohen was doing Trump's bidding? Isn't it a fact that there were the checks, each signed by Trump, for, quote, lawyer's fees? Now, anybody out there who's ever hired a lawyer, except for something very simple, signs a retainer. Okay, not everybody does it, but every state recommends it, saying what the terms of the agreement are, number one. Number two, the other thing that happens is that you specify what you do if you're charging someone by the hour or whatever, so that sum of money is not broken out. Then in addition, you have the participants saying there weren't any legal fees, and Cohen saying, I wasn't working on anything else. In fact, I was doing less during the period when I was being paid for services that were not rendered. Now, some think the cross-examination was, tough. Well, what I learned early on is that people think they know what a fistfight looks like. And they think they know, maybe because of Perry Mason and some of those shows, what a trial is like. But a trial is a messy business. And things change. And it's a form of chess. So, for example, say somebody asks a question, the defense, say, and you think, I could object. But I have a good idea what the witness is going to say. And he's going to come back and hit this guy square in his face with an answer he never wanted, in part because he's asking an open question, not a direct question. So, I don't object. I remain quiet as he asks the question and as Cohen answers it, hurting the defense. But the most obvious thing that is missing from the defense is any cogent story. They have a couple that they're trying out, but I don't think they're working, and we'll find that out in a couple of business days. But one of them is Cohen was so upset that he wasn't given a substantial position with Trump after the election that what? He made all this up? Makes no sense. So there are those, and I don't know why, there are those who think the cross-examination was dynamite. Not at all. One of my heroes, and I may have mentioned this before, and I have a number of them, was F. Lee Bailey. He had a classical way of conducting a cross-examination. And to give you an example, what you do is you break out things that a person has said before, and you look for other statements that are inconsistent. That may make the witness unreliable. You look for former statements, you keep them in your mind, and then at the trial, they say something different than that, and then you burrow in. Now, is the statement recorded and under oath? Even better. Is the statement in writing? Written by the person on the witness stand? Terrific. Does a person say something that is inconsistent that by asking direct questions you can show that they're inconsistent. But here it is. They didn't lay a glove on the basic story that makes no sense in any alternative world that Blanche can come up with. So if people are giving him high fives, great, he should enjoy it. And who knows, lightning could strike. But I still want to see how this jury finds one person on the jury to vote against each and every one of the 34 counts involving specific documents tied to an effort to conceal how flawed was Trump in the category of sexual abuse, bad taste, and what kind of person do you want in the White House who would conceal the truth of the matter asserted? Now, when will we know what vision of the cross-examination is true? Well, two things are going to happen. One is the prosecution is going to go through the material and tell us by questions of their witness, Mr. Cohen, why certain things don't matter. The things that some people think the government should have said in its opening. But you don't want to confuse a jury. You just want them to know, this guy is not an altar boy, nor is he a rabbi, nor is he a priest, nor is he an ethical man at all. Because if he were any of these things, and faithful to that teaching, he wouldn't be working for Trump. And he did say, like others who have joined the cult of Trump, how excited he was when Trump started to rely on him. So this is merely a stop on the road to conviction, in my opinion. But the stop is a sign painted in the direction of Trump, who has no intention of taking the witness stand, and probably no one else is going to take the witness stand. And so the judge is going to ask the jury to be patient while they go over the charges to the jury, and then have closings. The government gets to go first, the defense goes second, and the government cleans up. The case goes to the jury, and then we find out. In my experience, when the jury went out, whatever judgment I thought I had about the jury and what they were going to do, it went out the window. I had no idea what they were going to do. And now a couple of times, I thought for sure I had lost a case. One case, the jury went out, and I went up to the grand jury to present a different case in the federal courthouse at Foley Square. I almost no sooner got up there than I was told the jury had a verdict. And so I thought, well, fast verdict, maybe that's not favorable to the government. I had worked hard. I'd made a clear statement of what I thought was at issue. And so I went to the courtroom, and I waited. And the jury came in, and none of them looked at me. And I thought, well, that's a bad sign to me. They don't want to look at me because they're not going to give me the result. So I sat somewhat resigned, as sophistic as I could, and I waited. And it turned out the jury convicted. They didn't want to look at me because they did not care that I had advocated fairly that should be their verdict, but they didn't want to do it for emotional reasons. So that was very interesting. They took their oath seriously, and they were convicting this person. And I know this was true because I broke my own rule. There was no prohibition against this. I stopped a couple of jurors, and I asked them about that. And they said they didn't think there was any open question, and they thought the government, whom I represented, was right. but they didn't like doing it. So there you have it. That's the jury of peers making a decision that doesn't seem obvious, and you're trying to understand it based on a series of heuristic tools that turn out to be wrong. That is how quickly they decided, the looking at me and all of that kind of stuff. I had another case, a small case once, and I was the defense counsel. And I kept thinking the prosecutor, local state prosecutor, was selling the jury short. And then in his summation, he told the jury not to fall for Flannery's tricks. So I was in a playful mood, not uncommon. And I think in moments of tension, if you know where you are and what you're going to say, your burden of persuasion is lessened because you're not misleading the jury. You're anxious for a result when it may just be you're anxious to get it right. And so I was relaxed, and I came up to the jury rail, and I pulled down one sleeve, and I said, well, there's nothing up here. And then I showed him my other wrist. I said, there's nothing here, but I'll tell you how I tricked you. And they all leaned into it. And I said, when Mr. X took the witness stand up there, and I asked him such and such, he said this, bang. That was my first trick. He admitted that they were wrong. And I did this with several pieces of evidence. And my client was acquitted, but when the jury came out, the judge's law clerk apparently couldn't read their writing and first said, guilty. And the whole jury got up and said, no, not guilty. So my client passed into the netherworld and came back within a minute. So it's a dangerous business to predict what's going to come out of a jury, or the why of it, or the how of it. We got 2 lawyers on this jury. What are they going to do? I don't know. So that's what I got this evening. Those are my comments. I think it's always interesting to examine witnesses, and the more you know about the case, the easier it is to try to put things in perspective. But that's my perspective. I see a conviction if there's not something rotten in Denmark. So, good evening. I say goodbye to you from the Cathedral of Trees, which looks marvelous this evening. Bye-bye.